You mentioned trading at for 30.
Item number
13, hearing at 30.
Where the learned counsel for the petitioner, Matters that St. John. MS S. Kapurti. CGS. He is here, will record SS Rachna, Mrs. S. Roy. And CGS is present. Okay. After 3 weeks.
Yeah, Peter. I beg to mention item number 11, matter old term. It is we are newly engaged at work. We are at retirement. That is creative effort.
Prayer of the counsel for the petitioner, Matters and St. John. And be listed after 2 weeks.
Hello. Hector. After the petitioner was 40 years.
How do you presume or record our findings that this was a compassionate act? That is the crux of the issue. There is they have surrendered that we don't have any record. So if there is no record, you will have to satisfy that these are the materials which on the basis of which we can reasonably conclude that this is nothing but a compassionate appointment.
I have received one ballot regarding case.
What was your name? Monwara Begum. Now, Mr. Chupia,
My lord.
this was a format subsequent to Upendas. Is that it?
Yes.
Upendas is a recent phenomenon.
Yes.
You make a determination that she is a casual employee. On basis of what?
Casual employee daily wages on.
On what are those materials? How she is, and there must be something that she was casually appointed with effect from 2/3/1996. Is that it?
Yes.
So how do you determine that she entered into service as a casual employee on 2/3/1996? Tell us that, show us that material, Mr.
Oh, yes, actually daily.
You have this has been done after Upendra. So therefore you are aware that how she was entered into the service, there must be something. What are those material on basis of which You have stated that Monwara Begum, and engagement is date is 2/3/1996 and casual.
Casual partner. Daily wage earner.
Casual.
Daily wage earner, they should be paid in daily basis.
No,
But
that is not an issue. But on what basis you found that she was casually appointed?
Only these are the records, partner. They say that they are casual employee, these are list. They are
No,
nothing
that
else.
list was prepared on basis of something.
That is, they have joined appointed as a casual employee. Partner. The appointment letter.
Where is the appointment letter?
Appointment letter not annexed, my lord.
Huh?
Not annexed. They have not even annexed the appointment letter to ascertain whether she was appointed as a master worker or casual worker.
Is there admitted case? On date of my husband, I was appointed.
It's different thing.
Is there admitted case? Now, proceed.
So far, then it will come to the compassion appointment. My lord, I would like to place one case,
Hmm?
recent case, regarding this appointment. After that, he says, my lord, after that, automatically whether
Which repetition we are taking first?
और डॉक्टर पहले चेकअप एक्टिवेट
Monwara Begum. Huh? Which is-
I don't have time. The same
Seems.
manner we have filed in the case of Manwara. This is a para 18 lot to policy decision judgment. If it is suppose it's a compassionate appointment, how compassionate appointment is made? Para 18 manner. If compassionate appointment is one of the service condition of service and is made automatic upon the death of an employee in a harness without any kind of scrutiny whatsoever, the same would be treated as a vested right in law. But it is not so. Appointment on compassionate grounds is not automatic, but subject to scrutiny, strict scrutiny of a various parameters, including financial position of the family, economic dependence of the
No,
family.
that's correct.
These are the-
There is
so,
no
sir,
issue on that.
yeah,
Suppose there
so,
are some contenders.
So petitioner is engaged as a casual after death of her husband. It does not mean automatically she will be appointed to compassionate ground. It is not a appointment of compassionate ground. She is casual daily wager, casual employee, daily wager. So accordingly, she has been paid scale 50,000 something after Upendas. That is there is the Upendas in table 45. So according to this division of this honorable court, my lord, they are not entitled for regulation or in fact also pension. This is the simple case. Only this is the crux of the matter. He was paid the scale and petitioner payer is to regularize her service to pay pension so and so is not entitled. Not applicable. We have categorically stated here, my lord. That was the sympathy shown by the department that your husband has been dead, so you are engaged like that. So you, at least you
It's
can do,
compassion.
there's no compassion.
That is compassion.
No, compassion means it does not mean the appointment. Our office member is concerned, office member does not support us as an appointment.
Yes,
So my
You may kindly peruse the paragraph 4 of the
Mm.
it is for the facility. It page after the post as the skill level. That still clearly indicates that I was appointed because on date of my husband only I was appointed, not prior to that. Is there a certificate that on date of my husband it has been appointed on regular basis? They have appointed as a paragraph 4 of the
hybrid. Oh, video have one. Any active?
yes,
now let me kindly down to page 45.
yes.
Where is not connect the office Maranta. Anything the appointed skill for the it is significant. Here fellow paragraph leaving his family or leaving his family needs to immediate the to post of grade 3 and grade service not above the level of lower division access or the post of grade 4 service in the action of prescribed procedure of recruitment. Thus, officer appointment would be recommended regular in manner. But this scheme clearly indicates that the appointment should be made against the grade 4, not on contextual or casual basis. It should be regular.
Two things you will have to answer. Even if we accept the affidavit. Okay. First part is that you had a right, assuming for a moment, for appointment on compassionate ground in terms of the policy of 1983. Okay. Now that was not done. Last 20 years you did not have any grievance. Okay. If that be so, how do you address on how do you address assure this court that this is not an unreasonable delay?
But,
See, we are not saying that in a writ proceeding or under Article 226, question of or limitation act will be applicable. It's not. No limitation act is applicable. But it is equally well settled that unreasonable delay on the ground of unreasonable delay, we can dismiss your writ petition. The reason being, which is apparent in this case, to make a determination, we don't have any record as well. This is number one. Number two, to determine whether how your appointment proceeded. Because as per the scheme, it itself says that no compassionate appointment will be made except with the prior approval of the secretary of the respective administrative department. So whether your appointment preceded by any recommendation or anything on record to show that you were appointed in consideration of the fact that your husband expired.
that has been in clearly
No,
tried by
they
the
have not admitted. Say this husband died, we appointed. But if you insist on this page 45, then we'll have to go to the other aspect. And now we try to have this. They surrender this, we don't have any record. So if there is no record, we cannot determine on the basis, and this is where the reasonable period of delay comes into play. Isn't it? You become wise when the question of pension comes after retirement. How you deal with, how do you address this part, this aspect of the matter?
that is to right. Right to receive adequate salary or pension for sick time. Such cases might
Right to salary, I have a serious doubt because there are division bench judgments, Supreme Court judgments are there. Right to salary, 3 years limitation will be applicable. Our High Court says in division bench as then in a Agartala bench decision. Where is that judgment, Mr. Sutia?
My lord,
So far relating to that. So far relating to pension, it is a continuous cause of action. Do no quarrel on that. But right to get pension is when it is established that you are entitled for pension, then it may be continuous cause of. These are ideas. So you'll have to address this court.
Yes,
It's not that you will show some paragraphs and affidavit in this case and you'll get a relief. This case you'll have to argue at a different level.
Right.
It's not like that I have said this, they have said the affidavit. So court is to presume that this was a compassionate appointment. That cannot be.
as they have admitted that I was
Where is that
appointed-
admission?
that I was
Has they
appointed
said
on-
that this is an compass because the moment because we are dealing with a right which has been stated to have violated in the year when your father died, husband died.
95.
Husband died on 1993. man.
You are asserting a right which has been violated in the year 1993.
He was
Is that it?
appointed in- he was appointed in 1993.
So on that date, your right to appoint give you a regular appointment under the compassionate scheme according to you violated. On that date, if we had decided, there would have many probabilities. They would have come and said, no, we don't have any post on compassionate. Already you have appointed, so you are we can only accommodate casual. So I have given us casual. Otherwise, we cannot give her in casual appointment also. That could have been their stand. As on that, we don't have anything before us.
There was no appointment, it's an engagement, my lord. That's why appointment should be.
So on that day, what would have determined is being sought to be determined after 93 to 93, 2003, 2013, 2023. 30 years. So 30 years, what are you asserting? What are you ascertaining? You are not ascertaining your right of pension. Your right of pension will follow moment we hold that you had a right of appointment under compassionate ground and that right has under the scheme ought to have been a regular appointment. That right has been violated. Therefore, you for all meaning and purpose, your appointment is to be treated as a appointment or compassionate ground. Therefore, you will be entitled for pension. So we are not deciding the right of pension. We are deciding your right to be appointed on compassionate ground, is not it? So where is then you will have to answer us the reasonableness.
But from the affidavit, what I have stated, they have never stated in their affidavit that my case for appointment on compassionate ground was placed before the secretary of the department or was considered by the authority for regular appointment. They just say in the affidavit that on death of my husband, I was appointed as his witness. My case should have been considered.
Understand? That is you are arguing. So you propose to say only on the basis of that affidavit we will have to make a conclusion in a judicial review that it was a compassionate appointment.
Admitted case. It's their admission.
Okay, then address us on your approaching the courts, your laches.
That is, my lord, first of all, my lord, he has no choice at that point of time. He has 3 minor daughters. Had to look after her mother, daughters, whatever she was offered, he had to accept. He accepted that offer for the well-being of her daughters. Accordingly, my lord, her daughters were the body defeated of the daughter, my lord, became the for her sacrifice, my lord, daughters were given property. At that point of time, artist Malad had no time. He had no time. And after her retirement, when she Malad realized that uh, her appointment was so considered for on professional grounds, it was made on Malad casual basis, it has been made on regular basis. And her advertisement for pension has been denied only on the Malad basis of their wrong.
What is this page 32? Connection 9.
Page 36, my lord, one of the similarly situated person, my lord, he was paid on a gratuity on death of her husband. He was, her husband was also my lord, master worker, my lord. She was paid the gratuity. In that case, my lord, additional has not been paid the gratuity.
Are you entitled for gratuity?
Yes. In
Provision?
in many cases, my lord, they have paid gratuity to the person. The Honorable Labor Court also my lord, recently has held that in case of 60 workers, my lord, they are also entitled.
Under what provision of the payment of gratuity? Act?
Gratuity Act, Section 4 of the Gratuity Act. In Section 2E, employee has been defined.
Payment of gratuity.
Fine. Employee has been defined. employee means any person other than an employee who is employed for wages, whether the terms of such employment are expressed or implied in any kind of work, manual or otherwise, in connection with the work of road, railway, wedding, shop, or other establishment which this act applies, but does not include any such person who is under the central government or the state government is governed by any other act or by providing
That is definition of employee.
definition of
Now, who was entitled for this payment of gratuity under which provision?
it's section 1, my lord.
Hmm.
Section 1(3).
Section 1. Yes, Sutia, what you say about this point, payment of gratuity?
Payment of gratuity, my lord, she is not a regular employee. Number one, she was not government servant. She is a daily wager. There may be so many daily wagers, like the petitioner. They are not appointed on regular basis. They are not paid a time scale pay, my lord, as per government employee, my lord. So she is
Now,
petitioner,
definition says who is employed for wages,
wa-
whether terms of such employment are expressed or implied in any kind of work, manual or otherwise, in or in connection with work of a factory, mine, oil field, plantation, port, railway company, shop or others with which this act applies, but does not include such person who holds a post under central government or state government and is governed by any other act or by any rules providing payment of gratuity.
employed employee is governed by the section.
so
They are entitled to gratuity under section.
they are not regular. The petitioner is not regular. First of all, she is daily wage earner, my lord, a regular employee. So there is no record that she is appointed.
No, you come to the proviso to section 4, the subsection 2 of section 4.
For every completed year of service, a part thereof is excess of 6 months. The employer shall pay gratuity to an employee at a rate 15 days wages based on the rate of wages as drawn by the employee contract. Provided in the case of a P-rated employee, price is-rated employee, daily wages shall be computed on the average of the total wages received by him for a period of 3 months immediately preceding the termination of his employment. And for this purpose, the wages paid for any overtime work shall not be taken into account. Provided further that in case of an employee who is employed in a seasonal establishment or who is not an employee throughout the year, the employer shall pay the gratuity at a rate of 7 days wage for each session. So, my lord, to
per foot. it- 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 it-
That, yes, of course, that can be decided not by this court because many other factors are to be decided. That's why the reference is there. Yes,
So our affidavit, my lord, 10 of the affidavit, my lord, regarding this part of the gratuity, my lord, affidavit has not, my lord, say anything. But regarding her appointment and payment of pension, my lord,
Mm.
the affidavit is clear. As she has admitted, she is not appointed as a, my lord, compassionate appointment, and she admitted that she is a casual worker, is admitted fact. And she was not appointed, but was engaged as a, my lord, tail wager.
Mm.
So page 24 of the repetition of the penalty number 1, Manwara. Hence the question of Malad enforcement on compulsory ground and regular
Page,
kilometers. Page 24, next 6. Manwara, I don't know. Manwara, no?
page,
Page 24, next 6. This is the application she submitted seeking leave. বিহিতভাৱে আপোনাক অৱগত কৰোঁ যে
just a minute,
Manwara
I'm not,
বেগম.
why I'm not getting it. Respondent number 2, Mukut Fukan.
No, Manwara.
No, affidavit filed by the respondent number 2.
Affidavit, no, repetition.
Repetition.
Manwara.
No, that we have seen. In everywhere it is either daily wage
Daily
earner or
wage
casual
So
worker.
there is no
And
appointment.
somewhere skilled worker. This
Skilled
in her
Skilled
identity
worker within
card,
bracket means maybe skill.
that is why we have asked that she is well aware all throughout. After 30 years.
Yes, 30 years come and claiming that I have been appointed as a profession. How it is possible?
Where is your statement regarding that in the report?
I think there is no in this part.
What is your averment under you were compelled? You have no bargaining power. Tell us.
Paragraph 4.
Paragraph 4, which repetition? Yes. That's all.
there is
Hmm.
appointment of the draft.
Hmm. There is no problem on that.
Another aspect, my lord,
Which paragraph? This judgment,
another 2018-5 PMC,
paragraph,
paragraph 5, 6, 7, 8, 10, 11, 13, and 5, 6, 7, 8, 10, 11, 13. 2017 PLP 4 and 5.
then 17. Okay.
This one, 2008 CCLR. It first 3 lines of paragraph 5.
Which judgment?
2008
7,
CCLR
2008, 7.
2007 2 CLP, my lord, 4 and 5.
Okay. 2008 3 GLR 261, isn't it?
Yes, my lord.
Okay.
Here, my lord, paragraph 5.
Paragraph.
First 3 lines of paragraph 5. And my lord, judgment, my lord, I will be relying on my lord, paragraph 7, 8, 9, and 10. Not for 6, not 9. But
Hmm. Rule 31. Hmm.
condition of purchasing.
Hmm.
That is
Yes.
very
Hmm.
service of an officer not qualify for pension unless it confirms the following three conditions. A service must be under the government.
What do you mean by service under the government?
Another
Must be against the substantive force.
Okay, then
Secondly, the employment must be substantive and permanent. I was permanently against. I was. there
what
was
do you
no
mean
way.
by substantive engagement?
मतलब substantive indicates regarding permanent.
There must be existence of some post again which you have been appointed.
But there is
Here, your case, his case, whole case is that you were appointed in as a
Casual.
casual employee till you return,
I
isn't it?
this pattern.
Yes.
The employment must be substantive and permanent. The service must be paid by the company. I fulfill first with one and three conditions. The first and the third condition I fulfill. The second condition I do not fulfill. Then provided that the governor may, even though either or both of condition 1 and 2 of above are not filled, declare that any specified kind of service rendered in a non-gazetted capacity shall qualify for pension. And in individual cases subject to such conditions as he may think fit to impose in each case allow service rendered by a staff. When if I do not fit the condition for 2, the government can declare that service to pension. Now, Roshni kindly turn to page 63.
Yes.
Summary page.
Yes.
Office memorandum dated 12 September 1990. Pensionary benefit to the government pensioner family pension. In the government Assam circular issued under office memorandum number 22, a temporary government employee who retires after rendering temporary service of not less than 20 years under the government without being confirmed in any post is allowed to be allowed the pensionary benefit as available to a retiring confirmed government employee either on attaining the age of superannuation or on his being declared to be permanently incapacitated for further government service by the appropriate medical professional. This is similar to the declaration under Rule 31. That even the temporary service on completion of 20 years of
How
service,
the pension rule defines a temporary service? What is the difference between a temporary service and a casual engagement?
here it says, even if they are
Why
not
this
confirmed
temporary
against the
word
post,
is used? Because
they are
there are
temporary.
some rule, which rule I forgot, where it says that to be entitled for pension, service must be confirmed. Appointment are generally temporary. Service must be confirmed. But in many cases, government or employer do not confirm, though it is against substantive post temporary. That's why for those people, this temporary body is. So therefore, we will have to to uphold your argument. We will have to satisfy us first that temporary employee as prescribed under this office memorandum
So,
and a casual employee engaged on a daily wage are the same and one, because our decision will have a far-reaching consequences. All casual, moment we declare that all casual employees in state of Assam henceforth will be entitled for pension after completion of 20 years. Those who entered into service prior to 2005. If you want to propose that kind of argument, then you have to satisfy that this temporary includes a casual.
but in Gujarat case, there might have now defense of the High Court held that the ad hoc employees, they are upon completion of 30 years of service, they are entitled to pension.
So as
Or
the
after,
judge,
after completion of 30 years, the question of regulation does not come. That was upheld by the Honorable Court.
so as the Gujarat High Court judgment.
can I please the judgment?
Not prepare, you take your time. It's an important
Also
issue
to
the
prepare.
way you have,
So far this agreement, my lord,
Mm.
temporary and casual employee, if he wants to be a same. I say, my lord, this is not a pleaded case. If reading is not there, my lord, they cannot pay for any relief.
don't go so, don't go so technical.
So that's why,
Don't
my
go so technical. Let us understand what is the temporary, when it's a, suppose
yes.
pension code prescribes what should be temporary and when confirmation is required. It is not a fact. It is a question of law or good.
Yes.
So then its pleading is not necessary. Let us understand. He is arguing a point. Let us clarify that all time to come,
Definitely,
that it is whether casual will include a temporary.
temporary. So why word
For
is
the
casual?
purpose of pension, temporary may be a different connotation in different contexts, in different law. Temporary for the purpose of grant of pension might have a different meaning in the scheme of the act. Temporary in another act might have a different meaning.
Yes.
That may assimilate with the casual and temporary may be same, but what is the intention of the legislature in the act, pension code? And under what circumstances that notification was to be issued? He'll have to satisfy us.
In terms of pension
Uh,
rule 12,
mm,
a temporary appointment
Mm.
is an appointment carrying a definite rate of pay
Mm.
sanctioned for a limited. Doesn't say that should be made
Therefore,
against the
you argue that the temporary will mean a casual because of this definition. So we wanted you to argue in that level. You are arguing, stating the whatever you have stated, what they have stated in affidavit. That we also know, we can read that.
Yes.
That's why we fixed this method today.
So, my lord,
On that day, I said that this case, if you argue like a normal case, you will have to think at a higher pedestal, higher level.
so my lord, under rule 12,
Mm.
the petition is also for a start. Rule 12 of
Now, where is the requirement of confirmation for the purpose of grant of pension? Which rule prescribes that?
rule 31 prescribes
Hmm.
that my lord, a qualifying service has been defined as 31.
Hmm. Hmm.
Can't put a 31. I have to fulfill condition.
Hmm.
I have to fulfill condition. And
Hmm.
under the proviso, even if I fulfill the condition, then I am at my service required to declare.
Hmm.
And to support that, my lord, they have already the office memorandum dated 12 September 1999.
Where is the requirement of confirmation? See, Rule 12, you read it. That's why I wanted you to come prepared. Rule 12, read it, Rule 12.
A temporary
Appointment.
is an appointment carrying a definite rate of pay. Sanctioned for a
What is the difference between pay and wage?
pay rate is not paid on my lord,
You
daily
are not ready. Come to Rule 8.
pay, and pay means monthly substantive pay.
Monthly substantive pay. Now,
Yes,
how
sir.
that Rule 12 is applicable to you? Admittedly, you are on a wage. Come prepared. Heard that some like please this matter for
I
further
will,
hear-
I-
further hearing on, give a date next week. You will face many questions in this case. You'll have to be satisfied that your right, valuable right has been violated. Then only we'll go forward with the consider that your delay is not fatal. We'll have to be satisfied. Isn't it? It's not that only on the basis of sympathy we can pass for that. We'll have to give a reason to the order. If we want to allow you also, sustainable reason must be there. So you'll have to decide all these things. What is pay? What is salary? What is the temporary? Whether that notification, because that notification in terms of the pension rule, whether meant, we'll have to make a determination that there is no difference between a casual employee and temporary employee. To take that decision, we'll have to rely on, we cannot say on our own. We'll have to go to the definition given by the legislature.
Regarding definition of good level,
Uh,
after
if you are say that you are ready, we can still proceed today. So let us not waste time. 5-3, 5th of March.
Fine.
Come prepared if you want to
Okay.
prepare. Don't worry. Mr. Sutia, you also go through all these provisions.
So far, he has receiving the Maladi remuneration as per Upenda's care. There is no argument is necessary.
We do not want to throw away a citizen like that. We want to give a reason that this, you should know that this is the reason you are not entitled. Or we want a government to know, if we allow, that this is the reason why we have allowed. We will not pass any order which will have neither here nor here. That's all. Yes. What to do, Sukholata? Your sum and substance case is that there is no mischief on my part.
Yes, sir. No need.
I was very clear. I given you everything. This is, you have not done anything. You have taken my service. So whatever have been done is done, don't recover. Return me the money. And you rely on that Punjab judge.
It is squarely covered.
Squarely
That-
Okay. Now let us hear Mr. Gogoi.
But mischief part and misrepresentation other part is not there. Negligence part is there.
Now, so therefore, that part is admitted.
So that
Mischief and
mischief,
thing is
that
not
part
there.
is not there, right? This also
Now,
not there.
question is whether on the basis of negligence, you can recover them. That's all.
That part.
That's what you because you have done, you have proposed to recover.
Lordship. No, it's
So,
already returned.
already recovered.
CS already returned the money on
No, it did not return. You have recovered from her other fund.
TCR,
This year.
year.
Jan.
Lordship. Lordship. That part. Otherwise, that negligence part, Lordship may
Tell us, you help us
Yeah.
to take a decision in your favor.
Otherwise
She has
also-
satisfied us. So we are not hearing us for the time being.
Lordship.
Now we'll have to satisfy us that no,
Yeah, Lordship.
in case of a high post like this,
Lord.
where she was the in charge, her negligence is fatal and
Lord.
that negligence amount to her object to get the extended service.
Lordship. Lordship.
So this will be a kind of misrepresentation.
Lordship. Lordship.
I'm giving his argument. I'm not upholding that. Don't worry. Take your seat.
Lordship. So negligence, before negligence part, Lordship, I have got one judgment of the Honorable Appeal.
Okay.
His assessment judgment.
Hmm.
Where it says that even Honorable Court direction, intimator is there for continuation of the period. Suppose Lordship, the person should be retired on 58 years. He is claiming that his retirement age should be 60 years. As per Honorable Court's direction, he is continuing up to 60 years. And Honorable Supreme Court says that Lordship, if a person has to retire at a particular 58 years,
Hmm.
if he continues beyond the 58 years, then the entire money which he has received as a salary should be refund it.
Whether that Pandey Jagadish sir was this referred to in that judgment.
No, sir, that judgment not. It is his
Let us,
judgment judgment.
let us, huh?
His judgment judgment, Lordship. Same judgment, just I have one in the head notice there, another head notice not there also. I have seen it, Lordship, it was not discussed in the Pandit Jagadish also. Just his judgment judgment, Lordship.
Let us see the stand of the government affidavit employer.
Paragraph 5 onward, Lordship. Paragraph 5.
When you were supposed to return to 31/12, is that it?
2017 month, I returned 2018, 30%.
You became principal when?
Lordship, Lordship, that exact date is not valid. We don't have the document with us, but as per the affidavit of the respondent, Marriage has stated that on 1st of January 2017, I was a part of the governing body, which says that
Why you can have the instruction from your client when she become.
it's not.
That is very vital for us. We'll have to either we
Yes,
will
sir,
go.
I'll
You have that
Police
instruction.
take
Just have that
over.
instruction when she became, because I asked this question last time.
Yes.
So according to them, you became principal on 1st of January 2007.
Yes, sir, but that exact date was well very.
They say 1st of January.
Yes.
But what is yours then we want to know.
Yes.
That. How is secretary's role is defined in the provincial election service?
Yes, sir.
Nothing.
When
That
only
principle,
Lordship, non-government college management rules, some power is there, Lordship, governing body.
but that is no more here. Now subsequently
No,
that
no, that is applicable.
Huh?
2001 rules applicable regarding function and management of the colleges.
okay. What is that rule?
Assam non-government college management rules. Now it's also after 2009 amendment. It's also applicable for provincial colleges. I will place it now.
Okay.
For books today, Lordship.
Give him the manual. Give him the education manual.
Why the education will complete?
Have you filed any reply affidavit to their affidavit in opposition?
No, Lordship. Because the only stand which the government had taken is that she was the custodian. Because by virtue of her position, my lord, being the principal, only for 2 years, my lord. But by Stanford Lordship, the entry into service was in the very beginning, when she was the lecturer. My lord. We are not denying that she was custodian.
In 2001 rules, Lordship, there is a provision for Rule 7, Lordship.
Hmm.
Secretary to the governing body to report to the director, Lordship. The secretary to the governing body shall be responsible to report to the director about any deviation of financial norms and procedures or any loss of assets of the college immediately whenever it comes to it.
What about that issuing a retirement notice?
Retirement
Superannuation
notice, as per the Lordship, pension rule itself says that,
Hmm.
Lordship, before 1 year it should be, even Lordship, the employee himself also informed to the
What is that pension?
Lordship. Yeah, Lordship. My lord, may page 91.
Of pension rule?
91 of Lordship, I mean, I can read only one paragraph. Lordship. The office,
Rule?
the Lordship, it's a Lordship office memorandum of 1/2/1992. It's a part of the Rule 101, Lordship.
Rule 101.
101, Lordship. Lordship in page 91. If I mean, I can read only one paragraph.
Yes. Ensuring officials handing over charge on the date of
Lordship,
superannuation.
then my lord may kindly come to next page, Lordship. It's
Just a minute.
next page, Lord, it starts from Lordship, third paragraph, Lord.
Hmm.
The officers due for retirement.
Just a minute. It is impressed upon all concerned. The officer due for it.
Lordship,
Yes. Yes.
due for retirement shall also submit his pension papers to his administrative department 8 months before the actual date of retirement without waiting for intimation in this regard from his administrative department or appointing authority. Here the administrative authority is the principal himself. Under no circumstances will the officers have the right to remain in service after the date of retirement with the expectation of getting extension, re-employment, etc. So and so. Entirely that if no intimation is given to an officer about his date of superannuation, it shall not confer him any right to remain in service. Moreover, if any officer is found overstaying in service beyond the date of his superannuation, no proposal for regularization of overstay period shall be entertained, and the amount drawn during such overstay period shall be recovered from the DCR. No, regarding the recovery part was also there in the Rule 20, Lordship, Rule 2 also there.
Rule 20.
Rule 20, Rule 2 also there. Lordship. Rule 20 is in page, Lordship, it page 9, Lordship. Page 9. Lordship, I can.
Hmm.
Recovery of other government dues such as offer issue of pay,
Hmm.
allowances, or leave salary, or admitted or obvious dues such as house rent, postal life insurance, outstanding motor car, house building, traveling allowance, and other. Here it is of high to fail.
But that recovery is for the purpose of
Lost.
Rule 20.
Lost it. Lost.
When it is established in a
Established.
judicial
Lost.
process or dependent
Lost.
process, that
Lost.
this is
Lost. Otherwise also.
that is what Jagadish Sir Prasad
Yeah.
says. Even assuming that done,
Lost.
there must be a proceeding. You have not done that.
And other
We are
provisions-
not the disciplinary. Is that it? This is it.
other provisions also there, Lost. In page 198.
And now you cannot do departmental proceeding
no,
also
we
because
can- we can.
she retired
We
17.
cannot.
Now 24, 3 years or
Only
4
Lord-
years.
Only negligence part is there, Lost, as per 99, Lost, rule 1. Even Lost, page 198 also, there is a provision, Lost.
198
198, Lost.
rule.
It's a part of rule 184, Lost. Procedure relating to pension, Lost. 198, Lost.
Rule 198.
Page 198, Lost.
Rule
Rule 184, Lost.
184. Yes.
Every officer shall submit a formal application for pension in form number 1. An officer should
Just
in
a minute. Just
Lot-
a minute,
lot-
just
lot.
a minute. One 184.
page 198.
Just a minute.
Lot.
Every officer.
Lot. Every officer shall submit a formal application for pensions in form number 1. An officer should in his own interest submit his pension application for pension to the authority certified in Rule 188 or 192 as the case may be 1 year in advance from the date of his actual anticipated retirement. It's not a fact that only employer is lost if there is a negligence. As per rules, lost it. And in respect of negligence part, lost it. In the O'Neill case, Honorable Supreme Court says something is there, lost it. By the way. It is also discussed in the Rafiq Market case.
Which paragraph?
Paragraph 14, lost it. Paragraph 14, lost it. If lost it permit, I can read it, lost it.
Hmm.
We are concerned with the excess payment of public money, which is often described as taxpayers' money, which belongs neither to the officers who have effected overpayment nor to the recipient. We fail to see why the concept of fraud or misrepresentation is being brought in such situation. The questions to be asked is whether excess money has been paid or not, may be due to bona fide mistake, possibly effective excess payment of public money by the government officers may be due to various reasons like negligence, carelessness, collusion, favoritism, etc. Because money in such situation does not belong to the payer or the payee. Situation may also arise where both of the payer and the payee are false. Then the mistake is mutual. Payments are being effected in many situations without any authority of law. The payments have been received by the recipients also without any authority of law. Any amount paid received without the authority of law can always be recovered bearing few exceptions of extreme hardship but not a matter of right. In such a situation, law implies an obligation on the payee to repay the money, otherwise it would amount to unjust.
Here is a slight difference.
Lord.
Here case is that wrong fixation
Wrong.
and excess payment.
And negligence has
Here
not
is a case. Yes, you will argue that the
negligence.
ratio
Lord.
is that ultimately it's public money.
Lord.
So therefore, when public money, it will see that where is the question of fraud and misappropriation.
Lord.
Even for your negligence,
Lord.
public money has gone waste.
Lord.
We can very well recover.
Lord.
But here is another dimension that in fact her services were taken.
Lord.
Services were taken. Otherwise, you would have appointed some other person.
Lord.
They would have anyway. So that is the distinguishable factor.
Lord.
This will be your
Yes,
answer.
Lordship, because this case is not applicable because in this case the case of excess fraud. Because
No, I
this
am
is
not,
the- and
No,
Supreme
no,
Court
he's
is
not,
the-
he's not saying
Yes, sir.
that these facts are similar, but you
Just-
want to draw an
Concept.
analogy,
Lordship,
the analogy from paragraph 14.
Lordship.
Paragraph 15 says that it's a fixation of scale.
Yes.
But paragraph 14, what he proposed to bring out a ratio
Lord.
and a principle of law that
Public money is no.
question to be asked is whether excess money has been paid or not. Maybe due to bona fide use.
Right.
So if it is paid, it's a government money, you
Right.
recover it.
Right.
That is the principle he want to bring into in your case. Your reply is that no, it is not applicable because I have rendered my service,
And
isn't it?
Yes, Lordship.
But only disturbing factor for this court is that your conduct.
That is the negligence part, Lord.
Your conduct is not at all good.
Even Lordship, the service book itself says that if we go by the service book, then also in the June, is continuing up to Lordship December.
Okay, let us just first just note
Look.
out the date. As per your admit, your date of birth is
Lordship, 1st of December 1957.
1st of
December
December 1956. This is
57.
Huh?
57.
37,
57.
57,
1957.
57. Your date has been calculated as in the service book,
It's 1st of December 1958.
1st of December 1958. Now, as per your admit, you will have to retire
On 31st of December 2007.
on 31st of December 2017. Okay. You actually retired when?
31st of December 2008.
No, what you have said, Gogoi, that actually she continued till
Till Lordship is continuing till Lordship 31st on 31/12/2018 Lordship.
so there was a
Hmm.
actually what happened is there is a miscalculation by the clerk while back counting.
Lordship.
Okay, because she was a new teacher at that point of time, she did not have any control over it. Back counting, he missed 1 year because there was no date of birth as such. It was on such and such
Yes.
that she was
Yes.
age. So you need a calculation. I think he was
Yeah.
as bad in maths like me.
And
So he continued, he did a mistake. Now she took the advantage when she became the principal.
Yes.
She knew that my date of birth is so and so, I must return so and so. They have entered it wrongly. I have not done, let me have the benefit. So she had the benefit.
otherwise also Lordship, as per the service book law, it says that date of birth of Sukuntala Gogoi would be 12th June 2058. 1958 Lordship.
Which is
Last page of the service
Last page of
But
service
in the
book.
first page of the
Yeah,
service
and-
book,
and
page
Lordship,
26
And
says something else.
and it should be retirement on 31st day of June 2018 Lordship. Then also Lordship, if we go by the last page also.
where is the service?
Lordship, page number 40 of the petition, Lordship.
I have the scan copy Lordship.
Lordship, we annexed both the pages because it's the part of the service.
Okay. Where do we get that?
Last page Lordship.
Page.
Just I have
Okay, last page.
last page. That was there. If go by that also
She has
Lordship,
been returned from the principal 13 and 12. Date of birth of Sangama is B 25th of June 1958.
Lordship.
Why 25th of June 1958?
That was their calculation. Even that calculation.
Even there is a mistake on that.
Even that mistake also there Lordship. If go by that mistake also Lordship, then she stood on 31st June of 2018 Lordship. After that also she remained another 6 months Lordship. If we not go by the admit card Lordship, we go by the service book, then also Lordship 6 months is extra.
No, but there is a mistake on the part of the employer na?
Lord.
In both count.
Lordship.
While calculating at the last
Lord.
also at the entry
Yeah.
also.
They are the custodian Lordship.
But not
No, you were custodian at the time of retirement.
only taken
At least from 1st of when you become principal 1/1/2017.
Yes.
So you were aware on 1/1/2007.
But Lordship,
And so you ought to have reported to your employer, just see, this is, I am supposed to return 31/12/2017. Please do the needful. You have not done that. You become a principal secretary. That is where we are a little bit disturbed. You are a principal, it's not a grade 4 employee that he knows nothing.
being a principal or a principal, I find that everybody knows their birth date, my lord.
Of course, of course.
Yes, yes,
Therefore, as a college teacher, it was your principal, it was your responsibility to write to your employer, to the governing body, see, there is a mistake in my.
maybe morally wrong, but my lord, but not legally wrong, Lordship.
That will have to answer.
Yes.
Hard saving.
Lord,
Only asked to get the original ethics.
No, not necessary because we have recorded. Na? As per, no, just give a, is there any copy annexed
Yes, Lordship, in the affidavit.
in the additional affidavit?
Yes, Lordship. got
Okay,
the
okay, not
original.
necessary. Your record relates to what?
As the pension paper, C initial right, Lordship, partial right 31/17.
Okay, let us see the
31/12/17.
pension paper.
Pension paper 2. She rectified herself.
I leave it to you, Lordship.
Where is that?
18 was to converted to 17, Lordship. As it pension.
Anything on the decision, on the anything on record to show your decision, under what circumstances, any office note, something like that? No, who corrected this? One is 31/12/2018. That is overwritten. No, but see, but there is a correction in the column on 31/12/2017. Both is of her.
We asked if Lordship, the accounting general file an affidavit. Lordship, I need to verify whether it is.
No, this is your application. Your application. Here, Form 1, particulars to be obtained by the head office from the retiring government servant 8 months before the date of return.
Lordship.
In the pension papers.
That has been signed by you.
That form was submitted. Lordship.
Where is your decision? Where is your decision? Madam, even if we hold that you are entitled, you will not get this areas of license fee of rent occupation. You will not get it. How can you get it? You may get your basic pay for giving service, no other benefit. At best, that also you have not decided.
Honestly, I have heard so many times, Lordship, that the judges bench of Honorable Apex Court never discuss any other cases. Not a single case.
Can you give a copy? This is, I
Okay.
think this is your bonds for some
But
other purpose.
Lord may,
You take the citation and get a copy. Give the citation.
Lord, no, even Lord may keep it. Lord.
We'll return you back.
And regarding three judges pen, Lord, I have given the single pages copy.
That I have.
Lord. And Lord, that criminal case was discussed, Lord, in the three judges bench of Rofis Masis case. Lord. It is not in the two judges bench. So Lord may kindly in the compilation three judges
Okay,
bench,
that is there, na?
three judges
You
bench
just
of
click again.
three judges bench, Lord. And that was also Lordship nowhere discussed in any other case. Before two judges, there just three judges bench of Rofis Masis. Click market.
Mr. Medhi,
But aku but didn't even take up with me.
Okay. Not only against salary, you have some other excess dwell. There are some excess dwell in respect of areas enhanced salary, then wrong fixation of. It's not that every entire amount is on the basis of excess. Excess is around 15 lakhs. Others, total 20 lakhs something. Others are in respect of some other wrong fixes. Okay, saving.
We have already stated that
Ah. Saving.
the order which was senior president we need to examine that lot because we have not
Okay. Ordered Samran, please this matter for further hearing Friday.
Yes.
Okay.
will examine that.
You examine, keep the cited. And the rules here cited, also,
Yes.
we will have a,
Otherwise, service taken part, I am not submitting anything.
Huh?
Service taken given by her, that part I am not submitting anything.
that is where the difficult.
Lord, that
Keeping, no, since it will again come in the list, so you keep it, you give it on that day. It comes Friday for concluding argument of MS Gopal.
compilation for my lord may keep.
We'll keep that. It. Reply you. Huh? Why you need to fix them? We have never, sometimes we even do not see at the 2 p.m.
Definitely.
Then what will you do? Yesterday the same thing happened. We'll have to come back at 2. Okay, Thursday. She will only reply. Friday, your presence is not required. We'll Friday. She will reply on these judgments. Okay. We'll also apply our think over and again, and we may put some question.
Right.
That is the only factor disturbing us. Otherwise, your service is taken, but the conduct as a principal of a college.
That part, only that part. Otherwise, Lordship,
And your record, everything you have signed,
Yes.
you have declared, you are stating something different in your petition.
That,
I am aware they have
Yes.
committed mistake.
that,
This, that.
that is why this not the broader
Therefore, you have declared that you should retire on 2018. Then only they return. Then only again you have corrected this. How do you explain that? You say that yes, I am aware of this date of birth, so I should retire 2017. I have produced my original record. It is your mistake. You have
Yes.
wrongly entered date of birth. But at the time of retirement, had you taken this stand that yes, I am supposed to retire on 31st of December 2017. This is the application you do done it. But filing the application prior to 8 months, what you say is that you are retiring 2018. How you reconcile with your statement in the writ petition and your conduct in the application? That you satisfy Friday. Okay? Yes. Mm. When
Sometimes after 7th of
give a consensus.
it
12th month. 12th March is a Tuesday.
12 March. 12 possible, Masul? 12. I agreed to better and a concept for the parties. Please this matter on 12 topics.
If you
My lord,
Hmm.
my lord, pursuant to the advertised dated 9/4/2030,
Hmm.
a petitioner to the filed their candidate.
Yes, madam, your cases were item 5 and 6. Okay. In item 4,
My lord, but the petitioner was not called for the interview.
okay. But because ultimately some determinations are also made. Okay, the learned counsel for the petitioner submits that this matter has become infructuous. According to the petition stands close being infructuous. Mr. P. Chaudhary is present for appeals. So, then other orders you write it on the prayer of MS as per protocol. Please this matter on. 5 and 6. Yes.
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 My lord, this matter relates to not the regularization of the Gaon brothers.
Mm.
Lord, my senior friend, Lord, has relied on a judgment
Mm.
delivered by court. And if not some other judgment also been delivered, I am relying on these judgments also. There is an order.
Which judgment they are relying on? Yes.
My lord, it's the direct order by paragraph 6.
Paragraph.
Paragraph 3. Direct order of
And which judgment they are relying on?
after the judgment, the deputy considered rejected. And that rejection order is again presented by my lordship of Lord, I think can not be
We'll close this.
Fine.
Where is that rejection?
no, but the rejection is another case, but not this case.
Ah.
But that case of declared is not fair.
Where is the order of rejection? Yes, Mr. Hendrik, you are relying on which judgment? Nothing, these are nothing. Argue your case.
My lord,
No, argue. These should not be, these are giving unnecessary litigation. Let us decide whether you have a right for regularity. Let us decide. Or whether we can issue a writ of writ. Where is the decision of the deputy commissioner? Certain cases you should not keep in ventilation.
Hello.
That's all. Please give your deputy commissioner. Same district.
Lord, may I frame for I think it
Okay. List this matter along with WPC. WPC
my lord is 708
7008
81 7081
7081 of
20
2023 on 29th of February.
Right. Right.
Out of March.
Right.
These orders will not serve anybody's purpose.
Right.
Except lawyer saying that your case is not dismissed but disposed of. Nothing more. Nothing more. That happiness. It is disposed of, not dismissed. All determination has taken, you don't have any right. The selection is to be proceeded on the basis of that executive instruction. Okay. There is no fault on the executive instruction. If no fault,
Right.
where the question of direction of consideration?
my lord one lord they also
So we have given a stay
In some
in a different process, but
Gwalpara district.
Gwalpara was
They
something, there was a selection.
been the selection process.
Selection process.
That
Lord,
is
I am not going to submit unfairly, but there is a distinct between those set of Gaupura
And Dhubri.
and this set of Gaupura.
This set of Gavuras
purely
were
honorary.
purely not only honorary by the villagers.
Villager.
And in respect of Gwalpara, Deputy
appointed.
Commissioner rightly, wrongly
Pointed.
initiated a selection process.
Exactly.
They participated
2000 letters.
participated in the selection and they continued. So there is some semblance of procedure
Right.
of selection. That's why we pass a stay order.
Lord, fine.
And in 2000, my lord, there is a my lord that qualification also my lord that for the selection of the government. It was also SSLC pass. In that, my lord, that they have been my lord that appointed my lord as working as an honorary governor. They have not that their
But in case of Gwalpara, that qualifications was also prescribed. Selection was there. It was done by a competent authority, Deputy
Lord-
Commissioner.
Fine.
So in that context, we passed the stay order so far relating to Gwalpara.
in Gwalpara, my lord, some process is also they are getting the my lord salary.
No, I am not taking advantage of that order. Just bringing to the knowledge of my lord.
No,
Yeah.
we are aware of.
Obliged.
In a deserving case, we will not hesitate
Fine.
and will not pass orders, ifs and buts. Let it be clear.
Obliged.
Yes.
Yeah, Mr. Ankita, he came to court, but he was unable to.
Where is the impugn order?
Except 5.
Annex 5 page.
Page 30.
Who is for the union? Name. Where is the policy that they are relying on? Office order,
Page
Annex- annexer.
36. Page 30. It's 38 annexure 7 was revised from 9 lakh.
No, tell us when Central Civil Services Extraordinary Pension Rule is made applicable, admittedly. Now, by way of this, whether this is in addition to 39, pension rule 1939, extraordinary pension rule 1999, or in exclusion of the rule. Yes. Huh? Here, prayer of adjournment is rejected. Hmm?
The content that is I have suffered not out of my official, but Your Honor,
No, that we understand. That is not a problem. Suppose we held you are within your in active duty. Fine. There is no difficulty on holding that. Now, what is your claim? A disability pension in terms of Rule A3A of the Extraordinary Pension Rules 1939, or ex gratia of the
ex gratia
9 lakh, 9 lakh,
now reversed to 20
whatever, 9 lakhs or 20 lakhs.
because we
But
suffered
we need to answer whether this, by this memorandum, they themselves says that it is extraordinary pension rule is applicable. This is one aspect. And whether ex gratia can replace the pension when it is a statutory rule.
husband of the petitioner also suffered
Don't forget about who died. Here is a question of granting, claiming a disability pension. Disability pension is granted under Extraordinary Pension Rules 1939 under Rule 3A.
disability pension. The husband of the petitioner will give disability pension. And he expired. When he expired, now he is entitled to ex gratia payment as
No. So you want to give up your husband's
existing pension.
huh? She is receiving a disability pension.
Not disability, she is not disabled.
No. Your husband was asked to go from the service. What was the reason?
It's invalid.
Invalid. Now, what was the pension granted to you? According to you, nothing is granted. This is a compensation. Because compensation is an addition to your disability. Are you getting, did your husband got disability pension? So you want in addition to that, this ex gratia. So after your death, your wife, you are also getting the pension. You want the ex gratia.
Family pension.
Yes, where is SP Choudhury? Okay, if nobody is interested, let these people suffer. What can we do? Learned counsel for the. You are Mr. A Day, Learned Counsel, sub is that Mr. NC Das, Learned Senior Counsel. is having some personal difficulty. Accordingly, a prayer for adjournment on his behalf. Prayer is allowed, please release after 6 weeks. Yes,
That validity of the decree made by the petitioner of the Court of Jurisdiction. Yet
Hmm.
denial of not denial, not granting approval.
but that has already been granted. Some people, they have already granted.
Some
people have already.
You have not been granted. There is a judgment that this is a valid.
Now their stand is
Hmm.
not regarding whether the diploma obtained from the
Hmm.
degree
Hmm.
is similar. They say that we have obtained it.
Hmm.
Now the last round of application,
Hmm.
Honorable Judge directed them clarification. AIC
Hmm.
AIC was not a part. That's not.
Hmm.
They write that
Hmm.
they got right had concept. Court by choosing concept that they have done their part. That then concept of time. But it when the debate again. Now we have added the AIC as part.
Where is, who is respondent number 6?
The last is the CAD.
Respondent number 6 is the ICT.
Once their reply comes,
Because there is a specific observation by this court.
Yes.
Call Mr. Kyle. We'll take after some.
This colored take file exhibit colored. Connected case is fixed on 29th of February.
This matter may come along with that. Similar
Uh-huh.
to matter. This matter also come along with that.
Along with,
That matter WPC 4255.
when to speak.
29.
So it's similar.
He submitted that writ petition involving similar issues are fixed on
29 Feb.
29, similar issues being WPC number
4255 2020.
4255/2023 is fixed on 29th
Two.
of 29 to 2024. Accordingly, the learned counsels for the parties submits that this writ petition may also be listed on the same date along with the said writ petition. Prayers shall allow registry to release this writ petition on 29th along with 20.
Obliged.
Yes.
Want to continue the.
Huh?
The petitioner don't want to continue the
Okay. Learned counsel for the petitioner. You are Mr.
T Sheikh, my
Your name is there?
yes, my
Mr. T. Sheikh, learned counsel for the petitioner submits that he has instruction from his client that his client is not interested in pursuing the present writ petition. Accordingly, this and withdraw the same. Accordingly, this writ petition cell is closed, is dismissed on withdrawal. and appears for the petitioner report. That's the section. Next.
Kindly password for time being.
Hmm. Who is your senior?
Speaker also.
Huh?
Speaker also.
We have filed it review petition.
You have filed it.
Yes.
You come here. Where is the judgment?
Doesn't please put. Made it. Take up. The petitioner after due selection was appointed as placement instrumentation corporation on 55/1985 at the group. So second, his service was confirmed in that post on 21 1980. The appointee was promoted as technician grade 3 with effect from so and subsequently he was promoted on 4/12/1995 as technician grade 2 cadre. But while securing promotion to the technician grade 2 cadre, the petitioner was considered against the SC vacancy because of the SC certificate produced by him. And while securing promotion on 4/12/1995, the his senior colleague, Mr. B.K. Kupon, in the general category. Subsequently, the petitioner was again promoted as technician grade 1 on 12/9/2001. On 1/6/2006, the management issued a start memo where it was alleged that at the time of the promotion, his promotion from the technician grade to technician grade 2 against the SC quota vacancy, the petitioner furnished a false SC certificate. Although he does not belong to the tribal community and accordingly he was asked to support the charge of the misconduct. In his reply dated 7/6/2006, the petitioner admitted that he belonged to the Ahum OBC community but had mistakenly submitted the SC certificate and accordingly he apologized for his lapse and applied for exoneration to enable him to continue in service. Unsatisfied with the reply, an inquiry officer was then appointed. The petitioner participated and pleaded guilty of the charge before the inquiry officer. Consequently, the charges were found to have been proved in the report dated 12/10/2006. The district authority accepted the inquiry findings and issued the second focus notice proposing the penalty of dismissal. In his reply to the petitioner applied for leniency by projecting that he cooperated with the disciplinary proceedings and that he secured his initial appointment with the corporation on merit after due selection as a general category candidate. However, through the order dated 18/12/2006, the disciplinary authority ordered for dismissal of service under clause 39 to subclause of the standing order of the Namru unit of the Partizan Corporation of India, renamed now as the Promoter Valley Partizan Corporation Limited. The learned counsel for the petitioner, while accepting the charge of misconduct, submits that the punishment is disproportionate to the misconduct. So learned counsel projected to the petitioner himself who passed inform on so of an OBC category person, whereafter the tribal employees association on 11/9/2000 made a complaint to the management and accordingly it is.
What is the error apparent on the face of this?
Okay.
Don't argue on merit. Error apparent on the face of it.
Okay. While it
court took a view that he has issued a fake certificate or something like that, which pleaded guilty. So therefore, he was dismissed from service. Court took a view that he has used the certificate at the time of promotion. He was entered into the service and general category. You have also accepted it and promoted him. So therefore, court thought that, okay, give him any other penalty, because at the time of entry, he has not taken any advantage of any certificate. And those judgments relied on by the learned counsel for the respondent relates to fraud in the entry into the service. Therefore, there should be why should we review this in the parameter? Don't argue on merit that this is the law, therefore court has committed mistake. You go to the division.
Some document, initial appointment by the he has submitted as a ethics. Yes, so
Whether that is your finding in the department, that he has done this mistake at the entry into the service.
please indicate it. It
No, these are documents which you have discovered. Okay. Subsequently, according to you, whether this was a part of the departmental proceeding. What is the finding in your departmental proceeding giving the punishment?
departmental proceeding, he has admitted his guilt.
He
Department
has admitted his what guilt? That entry into the service or in the time of promotion. What was your charge? What was your charge?
page 36 the charge.
Tell us, what is your charge? Read it.
That Sri Netromani Burua submitted a caste certificate at the time of his joining in his corporation issued from Dhemaji District Tribal Commissioner in support of his claim of belonging to Scheduled Tribe. At the time of his promotion from technician grade 2 to technician grade 3, Sri Burua was considered for promotion against SC service. So therefore, the initial time of joining was also there. And in the proceeding also, he has admitted his guilt. The specific question was made put to it.
Now, where are you?
Case 49.
You are removed from service or you are reinstated?
I don't know. Senior counsel is another court. As well for time being.
Where is he now? Mr. Kolita.
Hello, what happened? It was order was passed there. They filed dispute.
Is there any stay?
What happened was here the take and he taken back the file. They are kept in the room and they are subsequently appointed as a member of the foreign affairs.
That you do not.
In the year 2000 or 2020, the petitioner also he was also waited. He was also
Forget about him. Whether you have complied with this order and only filed a review.
in the year 2020. The petitioner has filed second, wherein the order was passed for the reinstatement. And thereafter, when order was served upon us, that time we come to know that the matter was
Now, whether you have complied with that
Yes,
order.
yes.
Now he has been reinstated. Now he is working.
reinstated and accordingly was subsequent the year 2020.
Then what will you do here?
So, it now
Now suppose we allow this review. Now tell us.
he will again claim for 2020 back to it. Only that year, but so he has already.
You want to say there is an error apparent on the case of the record that charge was relating to his use of fake certificate at the entry into the service,
Yes, yes.
and therefore he was dismissed from service.
Yes.
And therefore the findings of this court that it was used only at the stage of promotion is not correct.
Yes.
That is error in the appendix.
Also, just now I did the chart map,
Hmm.
wherein the joining is also there. Case 49.
Read it.
Have you understood all the charges? Yes. Do you admit all the charges? Yes. That means the initial joining also there.
Now thereafter any
now-
departmental proceeding? Any
Yes,
departmental
yes.
proceeding?
Person to department.
Now, who said that this is a fake certificate? Where is the finding in the inquiry report that his entry into the service was on the basis of a fake certificate?
Okay, circle officer also reported that.
No, don't say. What is the finding in the inquiry report? We are not we are not an appellate authority or a departmental authority. Why don't you understand? You tell us what is your finding. Don't try to convince us. We want to know your finding.
Inquiry report, Lordship, ultimately going to the findings, Lordship.
Hmm.
On hearing the
What
charge,
is the findings as regard his entry? Because the court held that the punishment is not proportionate or punishment was disproportionate because he used the certificate only at the time of entry into the at the time of promotion. Okay. Now your case is that error apparent on the face of record is that his charge was that he used a fake certificate at the time of entry into the
Yes,
service. So therefore,
certificate,
what is the finding as regards that charge by the inquiry?
that was admitted, Lordship. Yes, so on hearing the charges presented by the present officer against the
So
prisoner,
you want to say on his admission, he was punished, no further departmental proceeding.
person, that was, I have read the department proceeding of the department.
No,
That
no.
was the
What
proceeding.
she said, there is a departmental proceeding. You ask him whether these are the charges, what do you say? He admits. Whether you proceeded thereafter
Yes.
by bringing evidence.
I think
So we want to know what is the finding of the inquiry officer as regards his fake certificate.
yes, only finding is Lordship. Charge have to accept the charges also. The following find were made. The Netromani Purua submitted a caste certificate that years at the time of his joining this organization in support of the type of belonging to type community. The Purua does not belong to ST community, he belongs to home community in lieu of ST society community as intimated by the district authority Dhamati High Return was the certificate produced by Sri Dhamati is fake and false and was not issued by Dhamati district committee of all Assam tribal Sankor. Its seal and signature of the state caste certificate is also fake and false as claimed by Sri Aditya
Okay.
Saklari.
So
Yes.
therefore, there was according to you, there is a determination by inquiry officer. That determination has not been interfered in the earlier round of litigation. And therefore, the finding that it was not proportionate for the reason that he used the certificate at the time of promotion only is error apparent on the face of the record.
And while applying for the case from 88 to onwards, here his application for employment. Wherein also he
No,
returned
that we are not to look into. If there is a finding and the court's finding is reversed to the inquiry finding, then it's a case of review. We'll recall the order and hear the matter.
the honorable state court judgment also held that Lordship, it is not material that what purpose that it is only because it is
No,
something
that
which
is you are arguing on merit. Merit of your claim. That he should be dismissed. These are on merit. That's why I ask you, you are on a review. Review will have to show that these findings is error on the is a error result of an error on the face of record. So your error, according to you, that court came to a finding that he only used the certificate at the time of promotion, therefore punishment should be lesser. But your case is that this is not the material on record. Record was that he used his certificate at the entry into the service. Therefore, while passing this judgment, this is the error apparent. So if we are satisfied subject to what he says, this is an error, then we'll recall the judgment. Then we'll hear the matter afresh.
only now it back with but in this
Back wages, Mr. Kolita, will we decide the back wages? We will decide whether we can recall this order. We'll either we recall it or dismiss the review. If we recall it, it will go to the bench as per roster to hear the matter afresh. This is the procedure. That's why you cannot argue on merit. Yes.
Whatever time being senior counsel is another court. And senior counsel will submit argument.
And what are the other matters?
2020 thereafter
No. What are the connected repetitions?
for non-compliance of the order he has filed.
What is WPC 3008?
If the petitioner has filed it.
Okay.
And
Then
with respect to the order was
what is IA?
I for getting the stay order.
What is the stay order?
Directing to reinstate.
That you have, that these two matters have become impact. We have to decide. Yes, Act 2. Act 2. Yes, Mr. Sharma.
The matter,
Hmm.
we are some officers working in the some Grameen Vikas Bank.
Okay.
We were under some rural banks, your lordship.
Hmm.
We were amalgamated to form the Assam Grameen Vikas Bank. And we came under the canopy of United Bank of India. What happened, your lordship, that during our tenure of service, there was an agreement between the Indian Bank Association and the bank regarding quiz revision. Your that there is a joint note prepared by the, that is at page 17.
I think I should not take up this matter. Similar issues, that National Tribunal, what was by justice, some Supreme Court judge was, High Court judge, Chief Justice was appointed, and that parity, isn't that it? So they were directed to be granted parity with different banks. Tripartite settlement, isn't that it?
Yeah.
Tripartite settlement. Thereafter, on every tripartite settlement, they were granted some benefits, some were not granted. Then I appeared for the union on this issue and relief was granted. So I'm well versed with all the facts. Let me not take up it. Please this matter before any other bench. Without. Okay. But date also difficult. Tell me that. When will be convenient for you? I cannot pass an order except will not direct anything. You make a mention before the appropriate bench. Because when I cannot take up, I cannot pass any. Better not to take up. I have only a set of. No, I cannot.
There will be no.
No. Generally, we do not.
Yeah, plus
Allow us time to instruct.
Simple instruction.
Lordship,
Your 1 minute instruction can help us in determining the issue. That's all.
our name is
Not reflected. Okay. This court under its order dated 12/1/2024. Observed that. Opined that, not observe, opined that affidavit on behalf of respondent number 6 would be essential for the purpose of a just decision of the issues involved in its petition. Full stop. It is submitted that name of Mr. S.C. Kyle, learned counsel representing respondent number 6 is not shown in the cause list. Registry to list this matter. However, on the request of the court, Mr. Kyle is present. Accordingly, Mr. Kyle submits that he is awaiting for, accordingly to Nalaga. Mr. Kyle submits that he is awaiting for the instruction and some time may be granted by the prayers and allowed this matter after 2 weeks on a date to be fixed by the registry.
All my colleagues.
Okay, on 7th of March, 2024. The 2024 registry to list this matter, reflecting name of Mr. S.C. Kyle, for the respondent number, representing respondent number 6 in the first list.
No.
Just Mr. Kal's short question, whether the same qualifications others are promoted in different department in Assam. There are some judgments also by single bench as well as affirmed by division bench,
I'll obtain.
saying that this is the qualification. Here a slight difference. Those persons studied some institution. Here is a virtual mode, or what you say,
What is the distance?
Huh? long distance, distance mode. So only issue is whether AICT approves such long distance mode or it's a validity.
I'll obtain section and test.
If that is placed,
Okay.
method.
Okay.
Okay.
One.
Yes, RM does for 1, 2, and 4. 1, 2.
Yeah.
1, 2, 0, 4.
1, 2, 3.
1, 2, 3. So that's why 1 TO 4. Only 1 method. See, Kyle,
Sure.
our situation.
Ah.
Nobody is interested in cases.
That is a problem.
What I could understand from his argument is this, that there was an allegation of using a fake certificate at the entry into the service. Charge was at the entry into the service. Now listen what he has. Entry into the service. Now there is a departmental proceeding. You also admitted whatsoever. Finally, it culminated on a order of dismissal from service on the ground of SARS being proved. Okay. Now we come before this court. A court has not entered into the merit, but on the basis of your admission and all whatsoever, court says fine, but it was used at the time of promotion.
Correct.
Isn't it? So it was used at the time of promotion. Therefore, the punishment is disproportionate. You could have demoted him or something like that whatsoever. So you take any major penalty, but not dismissal.
Well,
Yes.
Manoj, in that order, prior to that promotion,
Mm.
it was me who has tried to rectify the thing. That is from where they have come to know. That is there in the
No, we'll come to that. Because we are on review.
review.
I have also reminded him that also, that we are not on a merit at this stage.
Correct.
Subject to the condition that we find it, there was an error apparent on the face of the record,
Correct.
will not enter into the merit.
Correct.
And even if we find that there is an error apparent,
Correct.
today we are not going to decide the matter on merit, assuming for a moment. What at best we can do is recall the order and he fix it for hearing.
Hmm.
That much we can do. So his case is that therefore, when SARS was there, that SARS was there, that this is an allegation of entry into the service. So it was error apparent of the face of the record. That is his argument.
It was not in the NP. NP, I was always a general kind from the appointment letter.
No, we will not go to the merit.
Alright.
We will not go to the merit. Whether you are
The court held, my lord, I was appointed on general condition.
now,
Correct.
let us go to the
Page 61 in my writ petition.
page 6. No.
In my writ-
In the review petition, let us see in the review petition.
my lord, there is also a writ petition. You
Hmm.
will find.
No, that is a letter cause of action. We will go to the review. Where is that review?
Page 84, I think.
Page 8. Yes.
My lord, at page 86, at para 4, page 85. The disciplinary authority accepted the inquiry.
See, kindly come to paragraph 3.
Three.
In Annexure 12, the management issued a SARS memo
Hmm.
where it was alleged that at the time of his promotion from the technical grade 3 to technical grade 2
Hmm.
against ST quota vacancy, the petitioner furnished a false certificate, although he does not belong to tribal community.
Well.
According to them, this is an error apparent on the face of the record.
Well.
Why they are saying, where is the SARS memo?
Is 36.
Page 36. According to them, this is an error apparent on the record on the basis of which the final court came to a conclusion that it is,
Prior to that, when the court came to conclusion, my lord,
no, before that, just come to page 36.
One number.
So their case is that you have issued that certificate you produced at the time of entry. Court found that it was already at the on the time of promotion. This is his first graph.
Right.
So they say that it is error on the face of the record.
my lord.
The search sheet itself says that it was in the entry. Okay.
Page
49,
90,
page
page
49,
90.
page 49. Okay.
Now,
Question number Q. Question number
what is the inquiry report?
inquiry report reported, but proceeding docket
No, proceeding will come later on. Where is the inquiry report? Proceeding, we are not concerned.
43.
Where is the finding?
Page 45. Eight 8.01.
See,
Inquiry
page 45, findings A.
8.01. Inquiry to ask the charge employee the following three questions.
Oh, Mr. Kolita, I am time and again saying we are not on the merit what you have said. Do you want to decide that your certificate is fake in a review petition? What we are limited to, what is the error apparent on the face of the record? In a judgment, even if we think that there is mistake in the judgment on law point, we cannot get to review it. You go to the division bench. That is not the issue. Issue here is what is error apparent. According to him, that these materials were available. This was the source, this was the finding. Now this court came to into conclusion that he has used at the time of promotion only. Therefore, it was lenient.
Page 90.
Okay, that's why. That is the limited question here,
Page
review.
90.
Huh?
Page 90, 90.
Page 90. Yes.
Additional recruitment, number 14, Sri Netromani Borua, general candidate. I was appointed in the general candidate.
That we understand.
So
You
we
were-
were not, Malad, we had not been NP into a ST certificate. Our NP was as a general candidate. ST prior to that is at serial number 4,
Where page 90.
90.
Page 90.
serial number 14, bottom
13, 14.
14, Netromani general.
What do you get general?
Malad, it is because
Additional.
I placed, my lord, your lordship in page 90, serial number 4 is ST.
Hmm.
Serial number 7 is ST.
Hmm.
Serial number 9 is ST. For the tribal people or the, my lord, reservation people, reserved people, it was stated. And others are general. I was appointed, and that was the finding in the court that I was appointed as a, and the judgment, my lord, your lordship will find
Okay, let us see the judgment.
judgment at para, it starts from para 4. The disciplinary authority accepts the inquiry finding and issued second show cause notice from penal discipline. In reply to such, the petitioner applied for leniency in proceeding the corporate with a disciplinary proceeding and he seek the initial appointment with the corporation on merit after due selection as a general
Which
candidate.
paragraph?
Para 4.
Okay.
Corporation on merit after due selection as a general category candidate. However, through that, the disciplinary order dismissal of service. Then, my lord, I will skip over to page 87. Page, paragraph 7, page 86. Paragraph 7, page 86. paragraph 7. Relevant will be para 9.
Yes,
Para 9, my lord, relevant. One may also consider the fact that delinquent himself informed the tribal employee of furnishing the undeserved ST certificate, and the falsification came to light at first instance from the delinquent himself. This indicates the dawn of realization of his mistake and the petitioner attempt to rectify this.
yes.
Page 88 is his initial name, wherein he has himself is written that he actually copied. Page 88. Application form.
Tell us where is he has entered into service that the findings of the court that he entered as a general category.
Yes, himself.
No, he has given, but you have selected him as a general category.
But he was selected Lordship only because of the initially 10 post was notified. Subsequently 12 post was.
No, we do not know.
And
We do not know. Show us that this is error apparent that he was appointed against the ST post. Show us. Show us that. Show us that.
He was
Don't go on merit. Show us that he was appointed against ST.
that is there is no
Hard.
but Lordship, I want to rely on a judgment.
Don't just rely on judgment on merit. Huh? Rely on judgment on review. Time and again, I am saying that
Can I
this
place
is
one judgment
there
of
should be an fake entry. This should be not entered, and these are merit go to division bench. That has already been considered. Heard Mr. Kalita, learned counsel for the petitioner.
review?
Also heard Mr. P.K. Rai Chaudhary, learned counsel for the respondent. Full stop. By the present application, by the present application, the petitioner has sought for review of order dated 21/7/2015 passed by this court in WPC 261 of 2007. 2007. The background fact of filing the aforesaid writ petition can be summarized as follows. The petitioner, after the respondent number,
In review petition. Review petition, I am. Petitioner, they have only one matter. Respondent.
the respondent, sole
It will be
respondent.
four. Respondent number 4.
You are
No, my lord. Sole.
sole. The sole respondent was appointed as tradesman within bracket instrumentation in the petitioner corporation on 15/5/1985 and 1955, and subsequently he was promoted to the post of technician grade 2 with effect from 31/7/1987. It was alleged that while securing promotion to the technician grade 2 cadre, the petitioner used an ST certificate on the basis of which he was promoted against a post earmarked for STP. Full stop. Accordingly, on 1/6/2006, a search memo was a search memo was filed against the petitioner alleging use of fake certificate, fake SC certificate at the time of entry into the service and using the same certificate for the promotion in question. Full stop. During the proceeding, during the respondent number 4, the sole respondent filed reply to such search memo and admitted that he belongs to a home within bracket OBC community, but had mistakenly submitted the ST certificate and accordingly apologized for his lapses and applied for exoneration. Next, though the respondent petitioner admitted such guilt, however, the employer proceeded with an inquiry and then an inquiry officer was appointed and witnesses were examined. Full stop. After the inquiry proceeding, also the petitioner admitted his guilt. After completion of inquiry, the inquiry officer concluded the charges were proved, and accordingly, the employer inflicted penalty of dismissal from service. Being aggrieved, the writ petition being WPC 261/2007 was preferred. This court, by the order dated 21/7/2015, of which the review is sought, held the following. One, though the petitioner, by virtue of his misrepresentation, secured out of turn promotion to the technician grade 2 on 4/12/1995 to a post earmarked for ST category person. However, he originally entered service on merit as a general category person on 15/5/1980. Next. Now, thus, the misconduct was committed at the time of promotion. Next, the delinquent himself informed the Tribal Employees Association of furnishing the undeserved ST certificate, and the falsification came to the light at first instance from delinquent himself. Next, this indicates the dawn of realization of his mistake and petitioner's attempt to rectify the same. Next, in the context of aforesaid facts and circumstances, the ends of justice will be better served by awarding any other major penalty provided under subclause A within bracket subclause B and subclause C of clause 39 within bracket 2 of the standing order for Namrup Unit of Fertilizer Corporation Limited. Accordingly, next paragraph, main paragraph, accordingly, the order of dismissal dated 8/12/2016 was interfered with, and management was permitted to impose any other penalty except that of dismissal and removal from service. Full stop. It was further provided that the petitioner shall not be paid any back wages upon reinstatement. Mr. Kalita, learned counsel for the petition, submits that there is error apparent on the face of the record for the reason that the a bare reading of the search memo clearly reveals that the search memo clearly reveals that it was an allegation that the petitioner used the fake certificate in question at the entry into the service. And the fact also remains that such service has been what people ask the people entry into the service, and facts also remains that not only the petitioner had admitted such misconduct, but such misconduct was duly proved through witnesses by the management during the course of inquiry. And therefore, there is an error apparent on the face of the record in finding of the learned finding of this court in its order dated 21/7/2017 that the petitioner has used his certificate for at the time of promotion only. Therefore, this order is required to be reviewed. Though Mr. Kalita tried to urge on the merit of the decision as regards being lenient when an employee uses or produces a fake certificate. However, in the considered opinion of this court, in the review proceeding, this court cannot sit as an appellate authority over the order dated 21/7/2015. That we have said only without looking into the judgment.
Only record regarding the application of the joining report, wherein he has stated that he has a
No, there is no dispute on that. Okay. No, there is no dispute on that.
only for my part.
No, Mr. Kalita further submits that the record clearly establishes that the petitioner, while applying for the service at the initial stage, relied on the same ST certificate which was held to be fake in the inquiry report. Therefore, such employee such punishment imposed upon such an employee could not have been reduced. Okay. কি করবো দেখো পিছর প্যারাগ্রাফটা বলো না It is well settled that a rehearing of a matter is impermissible in law in a review. Therefore, it is equally well settled that power of review can be exercised for correction of a mistake, but not to substitute a view. And such powers is to be exercised within the limits of the within not like no. Okay. Now coming into the case in hand, coming into the case in hand, if we look into the judgment, the order dated 21/7/2015, the court itself formulated an issue that issue whether the punishment of dismissal is proportionate to the charge misconduct in the case. While answering the issue that the punishment of dismissal is not proportionate to the charge of misconduct, this court, as discussed herein above, has concluded that the petitioner had originally entered service on merit as a general category person on 15/5/2018. No material has been brought on record to show that the such conclusion that entry of the service of the petitioner was not as a general candidate. That being the position, this court in a review jurisdiction cannot conclude that such determination was incorrect. This court by the order dated 21/7/2015 held the punishment to be disproportionate, considering the fact that the petitioner, the respondent delinquent himself informed the Tribal Employees Association of furnishing the SC certificate in question. And that the petitioner only obtained benefit of promotion by using such certificate, and therefore his removal for service was disproportionate. If disproportionate, this court finds no material which can lead to a conclusion that such determination is result of some error apparent on the face of the record. Full stop. The case of the respondent that his entry into service of the petitioner being bad, such person, not petitioner, relax of respondent is bad. No leniency should be shown to such an employee is a matter on the merit of the determination made by this court in its order dated 21/7/2015. And therefore, this court cannot enter into merit once again in a review petition. Accordingly, this court finds no merit in this review petition and sends dismissed. Review gone. Then
Petitioner, I am the petitioner.
what is
My lord, your lordship may turn to the
influx was?
not in fact, just my lord, your lordship may turn to page 11, order dated 10/9/2020.
10/9/2020.
Five years they kept the review petition as defective and allowed me to join on 1/12/2020. 5 years, my lord, was it my fault?
Any affidavit file?
My lord, this is the order.
No, any affidavit file?
No.
Filed the beginning application.
Huh?
During the pendency of the review petition, we have simultaneously file, say beginning application.
Okay, what is your ground? Tell us,
But,
how much cost?
okay, 2015, that order was passed.
Hmm.
Thereafter, the review petition was filed.
Hmm.
Earlier set of council has taken back the file and kept in his home.
Hmm.
The petitioner also, he was
Have you
also-
taken any action against this council in the bar council?
because
do that.
he was, but the petitioner was also silent. He was also staying in the matter. Okay, and in the year 2020 only he filed this petition.
Every time
From
we went to
2000
the
from
department, my lord,
2015
they used
No,
to
just
say-
take your seat. Yes.
from 2020 to
So meaning thereby that until and unless somebody files a contempt petition, we will not comply with this order, and that review is a automatic stay. So as the judge.
because the order was initially his appointment is in the Hindustan Fertilizer Corp. Particularly the BBFL came into existence in the year 2003. Thereafter, in the order was thereafter passed, and we have obtained the state documents and I could file the review petition. But the valid substitute due to fault of the council.
Now, what did you do? Have you taken any decision pursuant to the earlier judgment?
He was
Fresh.
That's I've given the document. This is on 2020, my lord, they have appointed me. 2020 for 5 years after the court order, contempt and the court order.
No. What is any punishment?
directly because lawsuit used the amount.
No. This court says your dismissal is set aside. You reinstated him in what? Promotional post.
No,
Uh,
no. Nothing done. After 5 years, my lord, when this happened, they have put me into that post.
Mr. Kolita, here you are in a slippery pitch. See, two things. One is this court says that your dismissal order is set aside. Reinstate him, and you are at liberty to inflict any punishment, but not dismissal and remove. So you had three jobs. First, you to reinstate him. Then, on the basis of the inquiry report, inflict a punishment. So, from the order of this case,
2015.
you did not reinstate him.
Of that review petition was
Review petition was filed, and you have also not taken and inflicted any punishment penalty. So
during pendency of the review petition when
don't take others' name. You are defending your counsel.
Yes.
Can you say that this lawyer has done? Then we'll ask the next question. What action have you
No.
taken against them? So don't take lawyer's name.
no,
You are not
I-
Mr. Kolita. We are we are not getting hello, Mr. Kolita. We are
Wait.
asking your client. You are before us representing your client.
what happened, I'm submitting that when the review petition was admitted, before that, single judge has put a question to that time senior counsel that what steps you have taken. That then the senior counsel has advised the corporation to immediately appoint.
Hmm.
And thereafter, after appointment lawsuit, the review petition was admitted. So the initial order was
You want to proceed further in this matter today or next week?
in the meantime it was prepared.
So pay him the salary from 2015. Take a fresh decision, whatever punishment you want to inflict.
to take.
Okay.
I'm in bad thing lawsuit.
Huh?
I am in the bad position lawsuit.
So you are not, your client is, you cannot do like this. What would have gone in reinstate him, give him a punishment? Now at the end of the day, court has not interfered with your decision. His challenge is negated. He has not gone upstairs. So his case is over. His punishment still holds the appeal, not punishment, the determination that he has charges are proved, he still holds the free appeal. Now your responsibility is to inflict him a punishment except dismissal and removal. You have not done it. So you have not done it, not reinstated him. So from till his retirement or you take a decision, you may take a retrospective decision in terms of the judgment, but pay him the whatever you want to do, you pay him the salary. Because your pendency of review cannot be a ground to bypass a order passed by a competent court. That may invite another aspect, a cost to be deposited before the legal services.
My lord, only thing I submit, my lord, a defective filing is no filing at all. 15 to 20. It was a defective file. And in the order dated 10/9/2020, it reflects that they kept it defective for 5.
Now this problem will be resolved. Now we are taking a decision that you file, it will be for a
15.
notice will be given to please correct this defect. If no, if
Same
that
as Supreme Court.
if it is not done, it will be listed before the
Lodged.
judicial order and all this. We will give a time for 5 days or 10 days, and we will pass an order with, if not done, without reference to, it's closed.
In Supreme Court, like 15 days.
Yes,
time.
yes. These are the things we are getting.
But you're allowed
Now,
to
what
make it
about
with
the
partner.
other writ petition 3008 of 2020?
That is my writ petition, ma'am.
And what is IA?
I is for packeting of the stay order.
Okay. You keep this to
I is
on
I
the
think,
prayer of Mr. K. Kolita, learned counsel for the respondent. Matter stands adjourned and be listed on 18th of March.
let it remain part of it.
No.
Okay.
The review we have done it.
Only my oxygen is that review petition. That was also dismissed.
Can I take those copies, madam?
Which
Right.
copy?
My appointment letter of 2020 and the judgment.
Three queries. But give me the judgment. I may quote your judgment.
Let
Where
it
is
remain, but that one only. I have given that appointment.
Look into the file. Huh? But you will not get the judgment this week. You'll have to find in it.
I may only take the appointment now. Subsequent.
You just go to it.